I'm Mariah Good. I'm the director of the Land Use Services Department. And I've got several staff people with me. I'll let them go around and introduce themselves.
I'm Becky Kerwin, the planner.
Jeff Cuso, zoning administrator.
Rick Brower, zoning administrator.
Sue Vanden Langenberg, zoning administrator.
Normally I would go around the room and have everybody introduce themselves, but there's a lot of people here and we've got a lot to talk about, so I think I'll just skip that. I know most of you, and you can introduce yourselves to each other later. So there's a bunch of things floating around. There's an agenda. Actually, you should have 6 different things. There's an agenda. There is a project scope declaration form. There's Act 67. There's an article by Brian Ohm. There's an American Planning Association handout. And then there is a memo, which should be familiar to all of you because it's something that went to the towns a couple of weeks ago. So, and there's also a sign-in sheet floating around, so please sign that as well. And I may actually sit for most of this. I want this to be really informal, including I've already told that staff members to interrupt me if I say something that is wrong or that they disagree with or are questioning, because we've been talking about this act, or both of these acts, but in particular Act 67, for a number of months. And even today, we were contradicting ourselves and arguing, because a lot of it is extremely confusing. And it's quite a big shift from how we used to do things. So please feel free to interrupt us and ask questions as we go along. I'm going to, I know I kind of made a nice neat list on the agenda, but these topics are mostly intertwined, so we're going to kind of jump around a little bit. Other than the sanitarian related item, which is mostly just an FYI, and I'll talk about that closer to the end. So I'm going to start off with the one that's relatively easy. So there were actually 2 acts that were passed this past fall that related to, or had portions of them that related to zoning. One was Act 68, and that one did 2 things that we needed to worry about. One is this amendment that you see up on the screen, which I'll scroll it up a little bit. We already had in our shoreline zoning ordinance the requirement that we have to have by state law that non-conforming structures or structures that have been authorized by a variance have to be allowed to be rebuilt. Now we have to add in this new provision which says that a structure that's in violation of a county shoreline ordinance that's been there for at least 10 years also has to be allowed to be rebuilt. So that's something new that we have to add to our shoreline ordinance. And the Resource Planning Committee is actually, the hearing for that is actually on Thursday already, among other amendments that they're going to be looking at on Thursday. So that's the language of the new one. It, like I said, mimics what we already have to do for non-conforming structures that are too close to the water and for structures that have gotten a variance in the shoreline areas. The second thing that Act 68 required us to do was we need to be tracking, and the we includes all of you as well, as in addition to whatever other county entities might need require a permit for something. So if you want to pull out the piece of paper that says Project Scope Declaration, Act 68, and we quoted it exactly on that page, says that if a project requires more than one approval or approvals from one or more political subdivisions, and the applicant identifies the full scope of the project with that first application, all of us need to use the rules that were in place on that date when we process that project. So for example, if somebody needed a town driveway permit as part of some giant project that they were going to do, and they come to you and apply for their town driveway permit, if they, as part of that application, identify the full scope of the project, which nobody has really defined, then all of us, even if they don't come to the county for 5 years to apply for their zoning permit, we need to use the rules that were in place on the day that they applied to you for their driveway permit. Does that make sense to everybody? I mean, I shouldn't say does it make sense, like, but so that's what that rule says. So what we Grant and staff and I came up with was this project scope declaration in an attempt to try and track whether or not somebody is saying that they're identifying the full scope of their project with the application that they're turning in to us. If you would like to use something like this, I can email you the Word document and you can doctor it up at your town level. Because what we're asking applicants to do is to briefly describe their project. And again, if they were applying to you for a driveway and all they said was, my project is a driveway, then fine. You can't come in 5 years later and say, oh, I also intended to build this big apartment building over here. No, you identified your project as a driveway. That's what your project was. So we're asking them to describe their project, and then we're asking them to check off whether or not this is the first application that they're filing for this project where the full scope has been identified, or have they already filed an application with another entity where the full scope of the project was identified? And if yes, who did you apply to and what date? So that we'll be able to contact you or whoever else it is. Could be the state, could be, who knows. So that's the second thing that we are doing because of that Act 68. I'm hoping it's not going to be that huge of a deal, but I could see that it might cause problems. I mean, we have historically had people, not to be sneaky, but that have applied for, you know, very large projects that maybe they're doing it in stages. They're doing the land division, and then they're doing, you know, part of a subdivision and part of another development, and it may be phased over a long time, and we have to use, if they identify the full thing, we'll have to use the rules that were in effect that first day. Yeah, Luke?
Right, does approval mean, does it include a political subdivision, like a town where its approval is only advisory to the county?
No, so it wouldn't apply, I don't, to like when we send you guys stuff to review to give input, it wouldn't be that. It would be like if there's something that you require, like you require a driveway permit, or if you had, I can't think off the top of my head, Egg Harbor I know has like approvals for design of buildings, if it's something that's commercial or that kind of thing. So anything where there's, yeah, you're right, it doesn't say permit, it just says approval, but that's not technically a requirement that you guys offer that, so it wouldn't apply to the town review part. So hopefully that won't be a huge deal, and if you want to copy this, feel free, and I can send you the Word document. Yeah, Dave?
But yet if their driveway application shows and indicates a subdivision, even though the request is simply for the driveway, that qualifies.
Right, it probably would. And it wouldn't be that, you can't make up that you want to do, you know, an apartment building somewhere where it's not zoned for that. Your application would have to actually meet the requirements that are in place that day. It's just that, yeah, you'd have to show everything that you wanted to do. And then if the rules changed and suddenly apartment buildings weren't allowed on that property, then we'd still have to allow it if it had been identified. So, yeah.
That language for your amendments there, can we find that in Thursday's packet?
Yes.
So that I can put that with this and we know
Yeah,
that they're correlated?
I had somebody call me earlier today about handouts that had intended to come. I'll email everybody that got the original email about the meetings, so town clerks, planning commission chairs, board chairs. I'll send you all these, all the handouts that you've got. And then as far as this stuff, this is right out of the packet from the RPC agenda on Thursday. So if you go on the county website and go on the quick links on the side and go to meeting agendas, you can get to the resource planning committee packet. So. All right, anybody have any questions on Act 68? And that was the easy one. So, Act 67. Oh, I should say, both of these went into effect November, I believe, 29th. Does that sound like a date? I'd have to dig through my pile. November 28th or 29th? 29th is when these went into effect. So, there's not really anything that you have to look at on this screen at this point at the moment. So Act 67 did a whole lot of things related to zoning, several of which we were already doing, and so we were already in compliance with, so I'll rattle through those pretty quickly. But so these are things that are new to the state law, but that Door County was already doing. One is we now have to let any non-conforming structure rebuild. So it doesn't matter whether it's too close to the road, the water, the side lot line, rear lot line, whatever. Any non-conforming structure has to be allowed to be rebuilt in the same configuration that it is before the rebuilding. We actually had already written that into the Door County Comprehensive Zoning Ordinance a year and a half ago when we split the shoreland ordinance out, because we have to allow that in the shoreland anyway for things that are non-conforming to the shoreland ordinance. So good news is we already had done that. Second, there were a number of items with regard to language that related to the Board of Adjustment and definitions of variances. We already were doing all of that anyway. We already had all of that exact language in our ordinance. I think they basically were taking pieces of case law and just sticking them into the statutes now. Maybe there were counties that weren't doing things properly. Third are that substandard lots have to be considered buildable if they're going to be building in compliance with the ordinance. We were already doing that as well. So substandard lot is what we've historically referred to as a non-conforming lot. It was legal when somebody created that lot, but now it would meet either current size or width requirements. Same thing a year and a half ago when we split the shoreland ordinance from the regular ordinance. We already have to allow substandard lots in the shoreland area to be built on, no matter how small they are. So we just went ahead and did that in the comprehensive ordinance as well, because a majority of the lots that we regulate are in the shoreland, and it seemed unfair to treat the two sets of property owners differently. Related to the substandard lots concept is that we can't, and we weren't already, we can't require lots to be considered merged. We, for many decades, had rules where if you had two substandard lots that were next to each other that were in common ownership, we called them one lot if they didn't meet certain requirements. But again, for the last year and a half, we haven't been doing that since we just went ahead and said that substandard lots are to be considered buildable. So the good news is that's less variances probably for the Board of Adjustment to worry about, and we're already doing those. So the main thing that Act 67 did that we were not doing was to make some significant changes with regard to conditional use permit provisions. So now what you want to find is the piece of paper that says 2017 Wisconsin Act 67. This should be floating around. So you actually have 3 handouts related to this act. So you've got this piece of paper, and there should be that Brian Ohm article that I think says Perspectives on Planning on the top of it, and I'll talk you through a little bit of that in a while. And then one that says Quick Notes from the American Planning Association that doesn't relate exactly to this act, but it'll relate to how we're going to be using it. So again, Act 67 went into effect November 29th of last year. So any conditional use permit applications that we receive after that date, and I think we've got 2 of them right now that are kind of in the works, have to comply with this, and our processes need to comply with that. So it's going to be a little bit confusing at the RPC for the next month or 2 because we still have, I think, 1 more month's worth of hearings under the old rules, and then we'll shift to the new as of May. Is that right? I think so. Hopefully not ending up with 1 meeting where we've got both going on, because that would be really confusing. So what Act 67 does with regard to conditional use permits, and all I did copy was the conditional use permit part. There's a lot more to Act 67, but I just walked you through the other stuff that's relevant. It basically, for the first time, sticks into the statute's provisions related to conditional uses. There weren't any before that. They're not really mentioned anywhere. It was all based on case law. And what it does is require from start to finish, whether it's the application or the testimony that's being offered at the hearing, or the decision that the Resource Planning Committee is making, or the conditions that the Resource Planning Committee might be putting on a conditional use permit application, it requires substantial evidence to be backing up all of those things. And that's going to be quite a big shift from how we have historically operated. I should also say, this piece of this act is what we've been going around and around and around about as staff, and also with Corporation Counsel Grant Thomas, trying to get everything straight in our heads, because it's extremely confusing, and there are some things in here that are seemingly contradictory. So it's not entirely clear to us exactly how all this is going to play out. So all the information and discussion we're having tonight is what we think we know right now. Somebody may tell us, either a court or an attorney or somebody later, that we need to do something differently, but because there's already debates floating around, especially in the legal community, about what this all means. At any rate, substantial evidence is required throughout the entire process. And there's a definition, if you look, it's about midway through the page. So it's facts and information directly pertaining to the requirements and conditions that an applicant must meet and that reasonable persons are going to accept in support of a conclusion. So you can't just say, I don't like this, or I'm worried that this is going to create traffic problems, or the applicant can't say, oh yeah, it's going to be fine, and just check the yes or the no or whatever the answer is on the application form. They need to provide reasons why they're answering the question the way that they are.
So,
And we can,
Mariah,
yeah.
excuse me, then the substantial evidence works both ways,
Yep.
both for the applicant and the opponents.
And that's what makes it really confusing. So I'm going to go, just so we have these up on the screen, or at least some of them up on the screen. What I'm pulling up right now, these are still in the packet of amendments that the RPC is looking at for Thursday. This is, or I should have said, existing ordinance text is in black, new things are in red, and I'll scroll down in a minute so that you can see the others, but I'll give you a minute to read those. This is what's in our ordinance now, and we're adding some things or tweaking some things that are the items or topics that the Resource Planning Committee is supposed to be considering when they make a decision. These are also pretty much almost verbatim reflected on the application that applicants need to fill out when they turn in a conditional use permit application. We are going to be overhauling that application though, because we need to make it clear that you need to do more than just check off a yes or a no. But so this, you need to have substantial evidence that relates to one of these things. We do have in the ordinance now, and we still will have, although it's now being listed as a standard, if you will, a general statement which relates to the impact of the proposed on public health, safety, and general welfare, which is obviously relatively vague, but that's supposed to be the whole premise of zoning, is that you're trying to figure out how to, you know, allow people to develop their property, but keeping in mind public health, safety, and general welfare. Yes?
Question, this is for the entire county. It's not for an area, it's not for a neighborhood, it's the entire county.
These
The way it's
standards?
worded now.
Right, yeah, I mean, this is the county comprehensive zoning ordinance, so the 9 towns that are in comprehensive zoning, this would relate to them. We don't have conditional use permits right now in the shoreland-only towns, because all we're regulating is the shoreland ordinance, which does not regulate uses. And that's in the other 5 towns. I can rattle them off if you need me to.
Thank you.
So substantial evidence, if you want to go back to your X67 sheet, is what's required throughout the process. If you go down to the next subheading, if the applicant for a conditional use permit meets or agrees to meet all the requirements and conditions either in the ordinance or that the Resource Planning Committee or Board of Adjustment might be imposing on the permit, it says the county shall grant the conditional use permit. Any condition imposed must be, 1, related to the purpose of the ordinance and be based on substantial evidence. So the difference there between what we have historically done and what they're saying that we're going to do, we've never really had people have to show at the actual hearing that they are going to agree to meet conditions. I mean, usually they do agree, because if they're not going to agree to the conditions, they're not going to get their permit. But the idea of them having to provide substantial evidence that they meet those conditions is going to be interesting, because you won't know until you get to the hearing what the potential conditions are that might come up. So that's one thing that we're trying to puzzle through as staff is, you know, I guess applicants are going to probably be advised to front load their applications as much as possible and to put every single thing in there that they think might possibly be relevant, or that the neighbors or the town or whoever might be concerned about. And then the part about any condition imposed must be related to the purpose of the ordinance and be based on substantial evidence. That's one that we've been talking about quite a bit at the staff level, because again, we as staff aren't going to know before the Resource Planning Committee hearing necessarily what items of concern might come up at the hearing. So we're not going to have studies or substantial evidence or things that we're going to have that maybe directly pertain to whatever it is that the Resource Planning Committee might be concerned about. So it's a subject of discussion, I guess, let's say, as to what exactly the Resource Planning Committee is going to be allowed to place as a condition. So I don't know if you guys want to add anything. This is what I feel like we spend hours talking about it.
So then you're going to delay the process for the applicant.
Well,
in a sense, I mean, there's the idea that the applicant finally gets to RPC and, okay, here are the conditions that they decide that day or that meeting to put on that application. To the applicant, well, wouldn't the applicant need to, wouldn't that naturally create a delay so that the applicant can look it over, agree, disagree, and you have time for your reaction?
well,
Are we gonna
that's,
delay the
that's,
process?
that's
That's
one
the thing.
school of thought, and actually when we look at this Brian Ohm article, you see that that's one of the things that he talks about. That's not ever how we've run anything, and if we're going to start doing that, it's going to really drag things
Well,
out, because
that's,
the Resource Planning Committee and the Board of Adjustment, when they hold a hearing, they can't just stop in the middle of it and table it. Or, well, they can, but then we need to do a whole nother notice procedure and mailing and everything else. So that's problematic in terms of really.
That's one of the concerns I had today was you get to a point and the sides can't agree, and maybe in order to gather the substantial evidence, you can't do it there, so you have to table the meeting and
then what? Yeah.
renotice the public hearing,
Yeah.
I guess. It'll
So
be a date.
What we've talked about with as staff, and what County Corporation Grant Thomas has advised the Resource Planning Committee, at least for now, again, until we're told that we're supposed to be doing something differently, is that if the applicant comes before the Resource Planning Committee and they tick through their worksheet that parallels all these topics that they're supposed to be looking at, and they feel that the applicant hasn't provided substantial evidence on one of them, that permit should probably just be denied then. So if the Resource Planning Committee, if the applicant doesn't provide any information about, or I keep using traffic for some reason because that's easier to wrap your head around. If they don't provide, if they just check, no, it's not really going to create any traffic issues, but the Resource Planning Committee questions that, or more concretely, if somebody on the other side shows up and says, well, I have a traffic study, or I've got the accident report from the Sheriff's Department for this intersection, and last year there were 5 accidents, and now you're talking about adding 20 more cars a day, turning left off of a hill, or whatever it is, then the Resource Planning Committee would have to presumably deny that application. But yeah, Monica?
Well, it seems to me that the planning department is going to have to do an awful lot more work with the applicants before it actually gets to the hearing. You're going to want to encourage them to sit down with you and say, this is what this means, what documentation do you have to meet this? Because this is what they're going to ask you for at the hearing. So it wouldn't necessarily say delaying all of the process after the permit is okayed by either the Board of Adjustment or the RPC. All the work has to come before it actually gets to the hearing.
It is going to be a lot more work on the front end, and I want to come back to that because you're exactly right, and we've talked about that to a great extent. But as far as the concept of whether or not we have to deny things or have to grant things or whatever it is, I definitely want to stress that this is all new to us as well, and so we're doing our best to try and muddle our way through these new changes and figure out what they mean, because if you read all of this and then you read the handout later that I'm giving you from Brian Ohm, there are lots of things that seem to contradict each other. So we shall grant the permit, except that the applicant has the burden of proof of proving that they provided substantial evidence on everything. Well, if they don't, then does the Resource Planning Committee have to have substantial evidence to deny it? Or, if an applicant or an opposition person just raises questions about it and the Resource Planning Committee decides, yeah, you're right, traffic really is going to be an issue here. You didn't provide any substantial evidence on that, therefore we're going to deny it. Those are all very gray areas, and I think the original intent of this law was to actually try to make it more black and white. I think the intent, because this is not the first version that went around at the state level. The original version, I think, was much more black and white. It was basically, you shall grant conditional use permits, and the hearing is for the sole purpose of figuring out the conditions, But then, like, our professional groups got involved and said, you can't do that. You've got to let there be some give and take and some opportunity for, denial. And so it got written the way that it did, which makes it a lot muddier. But to Monica's point, we've talked about this as well with the Resource Planning Committee and Grant Thomas. And what I said, and Grant agreed that this was correct, it's not, nor should it be, the zoning administrator's job to determine what is substantial evidence, because we don't want to, well, for one thing, the law says that it's the county and the zoning board, as they call it, that's supposed to be making the determination about whether or not the applicants met the burden of proof. For another, we don't want to put staff in the position of saying, oh, that looks great, Monica, I think you addressed the traffic issue perfectly well, and then you get to the hearing and it turns out that somebody on the other side has some traffic study which completely contradicts yours or is newer than yours or more specific to that neighborhood or whatever, and then the applicants are blaming staff for saying, well, you told me that this was going to be fine. So we will definitely be coaching applicants a lot more than we ever did, and we have, in addition to these first go-round of amendments that we're doing, I've so far collected a pile of paper this thick of stuff that we need to amend that are our application forms, our worksheets that the Resource Planning Committee and Board of Adjustment use, the introductory remarks that we make at the committee hearings, the letters that we send to the towns when we transmit the applications, the input forms that we give you guys to give us input. All of that needs to be revised to try and, as best we can, reflect all of this stuff. So I think what it will end up doing is, staff are just going to have to probably more collectively than we usually do with conditional use permit applications sit down and say, okay, Monica turned in an application and for traffic she marked that it's not going to be an issue and she provided a couple sentences. But somebody can say, well, yeah, but don't you remember 3 years ago when we had a hearing about something else on that road and people were really worried about traffic? We should probably tell her that she needs to provide a bit more than that. So I think that's the kind of thing. It is going to take a lot longer. So, yeah.
One of the complications I have reviewing this is essentially you are coaching the applicant, and the other side is getting zero coaching unless they come forward to you and ask you for it.
Yeah.
And that's one of my complications with this set of ruling, is you're trying to help the applicant to make it through the process appropriately, but the other side can make the argument that, well, you didn't give me that same afforded value, despite the fact that I didn't come and ask you.
Right. That's one of the reasons why one of the other handouts that you have is that the memo that I sent out to the towns last week with the rewritten policy for the town review period. That's one of the reasons that we are changing that policy, or I shouldn't call it a policy, procedure. So what we have done for 20 years is when an application comes in to us, we make sure that it's complete and then we send it to the town for review. At the end of 28 days, or when you get back to us, we then go ahead and start scheduling, whether it's Resource Planning Committee or Board of Adjustment. Even before this act came into being, we had been talking this past year about shifting that somewhat, because what we did allow over the past 20 years, and people didn't use it a lot, but it got used enough, would be that towns had the option, if they wanted to, of waiving their review period and saying, oh, we don't care about Monica's project, we're not gonna review that. So then we could just go ahead and start scheduling sooner. So that's one thing that was allowed that is not allowed anymore. The other thing that was allowed was Monica could go to the town and say, you know what, I know you guys are meeting tomorrow, so I want to get on, or 2 days from now, so I want to get on that agenda, because otherwise, if I turn in my thing to the planning department, I'm not going to get on your committee or meeting until next month. So we would let them bring in a letter from the committee with their application. We're not allowing that anymore either. And that's for two reasons. One, because of this act, and I'll explain how we're going to attempt to address neighbors in a second. And two, because we've had a number of large hearings in the last 12, 24 months where there's been a complete disconnect between the input that we get from the town and what the Resource Planning Committee hears at their meeting. Because the towns are using varying processes, and you can still use varying processes, but the towns are using varying processes as to whether they do or don't notify neighbors, whether they do or don't review things. And then when it gets to the Resource Planning Committee, we might have a complete conflict between what the town says it wants and what the neighborhood says that they want. So that's one reason that we're not doing that waiver anymore. is the towns are gonna, you don't have to review it, but we're not gonna speed it up. We're gonna sit there and wait for 28 days while you either do or don't meet to give us input. The reason, the other, yeah, go ahead.
I was gonna say, and then one other reason is just that when the town does receive the application materials from the applicant, it ensures that we reviewed it and made sure that everything's code complying, as opposed to the applicant bringing it to the town beforehand. The town provides a recommendation, and then we find out that the entire plan needs to be redone, which usually just ends up making that process and that much longer.
You're right, I forgot that. And the other reason related to that is when somebody goes to the town first without coming to us, you don't get our staff report that gives you the context about maybe the background of that property or why they need this variance or whatever it is. So that's the other reason that's related to that as well. As far as how Act 67 plays into that and why we revised that process, it's exactly what you were talking about, Dave, is so the town gets a lot of time now to look at something. You get up to 7 weeks, depending on how your schedule and the RPC or Board of Adjustment schedules fall. But the neighbors, unless the towns are doing mailings, which most of them don't, the neighbors don't find out anything until they get our mailing. And our mailing that we do when we send out the notices gets to people roughly 2 weeks before the hearing. So in a lot of cases, not time enough for somebody to make arrangements to be here if it's somebody that, a neighbor that doesn't live here year-round or whatever. And then now, given the fact that they can't just show up and say, I'm worried about traffic, they need to have some facts and information, we need to give them more time to pull that together. So what we're going to do is when we send the towns the email transmittal where we send your letter saying Joe has applied for this project and the hearing date's going to be roughly this, and here's the packet, we're going to take that letter and send a hard copy of it by mail to all the neighbors that we normally send the notice to. So they're going to get notified a month earlier than they have been. So that will give, and we'll make, and again, that's in the pile of stuff that we need to revise to make sure we explain like what type of input is going to be considered relevant. Yeah.
And to Dave's point about where counsel might come from, not sounding cynical about attorneys, but if law firms and attorneys don't jump all over Act 67 and promote their services to help people guide them,
they already are and locally.
Then they're not worth their salt then in terms of jumping on this.
I haven't seen the ads, but I've heard that that's
is that right? Yeah, I didn't see any ads either, but that would be a logical consequence of it.
It's the economic increase.
Yeah,
Absolutely.
Yeah, so people used to call this Smart Growth Law the Planners Full Employment Act. Now this might be the Lawyers Full Employment Act. So, sorry, I didn't see you. Linda.
So you're going to be sending this letter out to all the neighbors. At the same time you notify the town, is that what I heard you say?
Right, and
so then will it be redundant for the town to be sending letters out like we have?
possibly. What we're going to do, because I'm trying to not make any more work than I think we're already going to have, and that we already do have, is we're just going to copy them on the letter that goes to the town. And the letters, I'm sure you've all seen them, the letters that we send to the town say, Linda's applying for a conditional use permit to do this particular project. And then we put in big bold letters on the bottom of it. The applicant is responsible for finding out when, if, or where the town is going to meet to discuss this. And so then that hopefully will clue in the neighbors that they need to be paying attention to their town agendas. So yeah, I know you guys do a mailing, and maybe you won't need to now. Maybe people will just clue into your website and look at
I think so. Our mailing says when the meeting.
Yeah, we're certainly not going to try and send out a mailing that says Gibraltar's going to meet on July 12th. It's just going to be people, here's your heads up that they're going to meet, and we'll have to figure out what kind of a form we're going to put together that explains what substantial evidence is so that neighbors know how their letters are supposed to be written or how their testimony is supposed to be offered.
But keep in mind that does not replace your obligation to notify for your own public hearing requirements.
Right.
That's all I'm,
Well, yeah, and there's a wide range of what the towns in the county do as far as public input. We're hopeful that these changes to the review policy will help that a little bit, and so that people that care will pay attention on the front end at the town level, and maybe some of this stuff will get hashed out along the way, especially if it's going to be harder for the county to actually turn down these permits. If applicants know ahead of time, wow, the neighbors were really fired up at the town level about traffic, and, you know, because they can bring in their substantial evidence to the hearing if they want to bring more than what they had in their application. Maybe they checked off on the application, traffic's not going to be a problem because of X, Y, and Z, and then they go to the town level and they hear that, you know, the town and whoever else really thinks traffic might be an issue, and so then they decide to bring in more information, I guess, at the county level. So let's get back to the actual act language. So if the Resource Planning Committee is going to be imposing any conditions, they're supposed to be related to the purpose of the ordinance and be based on substantial evidence. I'm about a little bit more than halfway down the page. So what types of conditions can we attach? Or I should say, can the Resource Planning Committee or Board of Adjustment? They need to be reasonable. To the extent practicable, they need to be measurable. And again, they need to be based on the purpose of the ordinance and based on substantial evidence. So there's some debate internally about how exactly that's all going to work. If somebody just provides a couple sentences at the Resource Planning Committee hearing about why traffic isn't going to be an issue, but during the course of conversation, the Resource Planning Committee thinks it really is going to be an issue, are we then supposed to have a traffic study for them to be able to attach a condition? Or do they just say, you didn't fulfill your obligation of providing substantial evidence, you just put a sentence or two in there that said traffic wasn't going to be a problem, so we're going to deny this. So that's, yeah. And then that paragraph goes on to say that the county's decision to approve or deny the permit must be supported by substantial evidence. So, you know, if the neighbors bring in substantial evidence that, or that what the Resource Planning Committee deems is substantial evidence that traffic is going to be a problem, and the applicant is either provided no substantial evidence, or maybe they provided a traffic study that's 20 years old, and the neighbor's study is newer and better and more specific, the Resource Planning Committee can say, that convinces me more than what the applicant brought in. And we can think of no conditions that will solve this problem. So, yeah, Nancy?
It does seem a bit like a catch-22. If the applicant has to provide substantial evidence and they don't, but then the county must pass it, or if they don't have substantial evidence for approving it, it's like a...
That's exactly what we've been doing. No. So, yeah. And that's, like I said, that's why I think we've already, in May, when we first started having to process the actual hearings by these new rules, Grant has promised that he's going to sit in for several months, probably, with the Resource Planning Committee to help kind of observe and guide and walk them through, like, so should we really be granting this permit, or how exactly is this all going to work? So it is a conundrum. It does seem like it's...
And if I, to speak to the point that was brought up over here earlier, I could see where this could lead to neither having substantial evidence to approve or to deny, leading to a necessary study to gain substantial evidence, which would lead to a delay in the permitting process, which kind of makes people mad sometimes.
Yep.
Yeah.
Yeah, it does. Yeah, those are the exact debates that we've been going around and around with as staff. The rest of the act basically says, and for this, we've always done this part, a conditional use permit shall remain in effect as long as the conditions upon which the permit was issued are followed. We try our best to keep up, and if we hear from neighbors or towns that somebody's not living up to the conditions that were attached to their permit, we go after them and remind them what they're supposed to be doing. One thing we have not done that we are now apparently allowed to do is impose conditions about the permit duration, transfer, or renewal. We've always, for 50 years, said that conditional use permit runs with the land. As long as that use is being conducted in accordance with its original permit and the conditions that were attached to it, we don't care who owns it. If it goes from Bob to Linda to whatever. I don't know that the Resource Planning Committee is going to start putting a duration on something. I don't know if that was a bone that got thrown out there to say, okay, you have to grant them, but maybe you can limit them and see how it's going. I'm not quite sure how that part would work either. Because people aren't going to want to make significant investments in a project if you're going to say, oh, this is only for 3 years or whatever. So I guess that will remain to be seen as to whether or not that makes sense. And then the last bit, if a county denies a person's conditional use permit application The person may appeal the decision to the circuit court under the procedures contained in 59-694. So what Door County has always done is the Resource Planning Committee is the body that holds the hearing for conditional use permit applications. Anybody that's appealing those, it goes to the Board of Adjustment. Over time, it's shifted as far as how the Board of Adjustment processes those, but for what we've done for 20 years now, I think, we do a de novo review at the Board of Adjustment, which basically means a brand new hearing. They conduct a new conditional use permit hearing. And if anybody wants to appeal that, they go to the circuit court. So when you go and read 59-694-10, that section of the statutes is about the Board of Adjustment and about somebody appealing a Board of Adjustment decision. So we talked about it at the staff level and with Grant and with the Resource Planning Committee. And for now, because nobody's telling us otherwise, and you'll see in this Brian Ohm article, we're going to choose to think, or not choose to think, we think that the way that we've been doing it is okay. That we'll still go from Resource Planning Committee to Board of Adjustment to the Circuit Court. It's also interesting that this sub-E here that has that language about appeals clearly only envisions that an appeal is going to happen by the applicant if they're denied. There's nothing in here that talks about, the permit is granted and the neighbors of the town or whoever want to appeal. That's not addressed here at all. So that's kind of interesting as well. Does anybody have any questions?
I didn't think of that as, so what does that mean? It can't be denied if it's granted?
Well,
It can't be appealed.
Or appealed?
I don't know. I mean, we still have language in our ordinance, and I just went and read the appeals, the Board of Adjustment statutes today, and that still says any person that's aggrieved by a decision now I forgot what the phrase was that it used, zoning or building inspector or zoning officer or something like that.
Exactly.
Can appeal.
There's got to be some way to appeal.
But that would then go to the Board of Adjustment. So that's what would be weird. If we were told that we had to switch and that anybody that gets denied a conditional use permit gets to appeal straight to circuit court, but if the permit gets issued and you, the irate neighbors or town want to appeal it, that you then have to go to the Board of Adjustment and then circuit court, that would...
Mariah, there are some counties that don't have an RPC,
Correct.
so the appeal would be directly to circuit court.
Right,
Yeah.
and that, we've been talking about that too, and you might be getting off the Board of Adjustment just in time, because
Well, that's what,
we've been talking about, we're not gonna do anything immediately, but maybe in the long run, what is gonna need to be happening for a variety of reasons is that the Board of Adjustment would process the conditional use permit hearings, and then it would go straight to court, and the RPC wouldn't be involved at all.
Well, the way the process is now, it gives the public two kicks at the cat, so to speak. And I think that we're all probably looking for some direction from the courts, even though the legislature created this. There hasn't been any legal cases yet challenging any decisions as a result to Act 67. So I think that this is still evolving.
Yep, yeah.
But to Rick's question, it's worded in a way that the applicant can appeal, not necessarily
Right.
somebody else can appeal.
Correct. Right. So if the Resource Planning Committee denies it, then it
Or
sounds
even
like...
approves it, as the case may be.
Well, right, I suppose they could appeal. We don't like the condition that the Resource Planning Committee set on there, although I'm not sure how that would work. Yeah, I don't know. Lose the attorney, maybe he can answer it.
No, I was going to bring up it seems like the legislative intent of Act 67 came from the all energy decision, and specifically the dissent. And that dissent said the time to really decide, to Nancy's point about, well, if there's no substantial evidence, does it go back to being subjective in terms of how it's granted? And it's implied, at least in the dissent in all energy, to say, well, it's the time when you consider the zoning to begin with, or amending the zoning, that you should think about where the discretion should be. So does that suggest then that the county and or the municipalities with overlays should be rethinking their zoning where conditional uses are now allowed, to say we need to do now some amendment and make it more specific So the subjectivity is gone?
That's exactly what we're going to tackle next. We haven't figured out exactly how we're going to do that. I think it's going to take many months as staff and resource planning committee and town officials, but that's exactly what we're looking at doing because, yeah, I mean, the case law in Wisconsin and the way that we've always done conditional use permits in Door County has been, okay, I don't want to pick, somebody give me a use that's not too controversial.
Trader contractors.
A trading contract, okay. Trading contractor establishments are conditional use in general agriculture. I don't even know if they are. But so they're a conditional use in general agriculture. But the part of the point of the Resource Planning Committee hearing was always, does a trading contractor establishment on this piece of general agriculturally zoned property make sense? Maybe that lot's really tiny. It's a really tiny grandfathered lot, and it's fronted on 3 sides by roads that are really busy, and there's just no way to make it safe for people to be going in and out with heavy equipment. So that's always been kind of the overriding thing that the Resource Planning Committee is supposed to decide. That's even in our decision letter language, that they have, the Resource Planning Committee has determined that there's going to be no harm to public health, safety, and general welfare, or to the character of the surrounding neighborhood at this location for this use. So it's a huge shift, but that's exactly what we're attempting to tackle at the staff, or I should say start tackling at the staff level. So, and again, we haven't talked in great detail about what would make sense as far as how to go about revising that. I think we were all going to look separately at the charts in chapter 2 and just kind of go through and say, okay, you know what? Maybe this use really doesn't make sense in this zoning district at all, even as a conditional use, and it should just be struck. Maybe it was put there for one person that did a project 15 years ago and nobody else has used it, or maybe it's just not appropriate. Or maybe, you know what, this is probably still fine in this district, but let's go ahead and add a list of potential conditions to the ordinance that would make it more clear what the trading contractor that's going to be in general agriculture needs to do. Or maybe, you know, we've had 20 hearings over the years about trading contractor establishments in general agriculture. 19 of them have been issued with the same conditions, and you know, only one time did a neighbor care. So maybe that should just be a regular zoning permit, and we write standards just into the ordinance that say these are the conditions if you're going to do a trading contractor establishment. Or maybe some of them just become regular zoning permit with no conditions. But it's going to be a lot of discussion and a lot of work to try and figure that out. And I know, yeah, I mean, some of your towns, like Liberty Grove, you probably have the bulk of the Heartland that's in the county. So if you guys want to start looking at Heartland and give us your input, that'd be fine. I think it's been on your agendas. So yeah, that's definitely going to be the next big step, and I foresee that taking quite a while, I think. So if you want to, actually, we've segued pretty nicely into this Brian handout. I almost didn't give it to you because there's a bunch of things in here that contradict what I just told you, which is what we've all been talking about and decided with Grant Thomas that we're going to do now. But there are some things about this article that are really good, so I do want you to have this. So the front page, I'm not going to read this to you obviously, but the front page I think does a really nice job. Lou just gave you a preview of explaining where this law comes from. And the authors of this law have been pretty upfront that it does have to do with that Trumbull County frac sand mine conditional use permit rejection or denial. So that first page is good in that regard. If you flip to the second page, you'll see there's a text box on the lower right-hand side. That does a really nice job of just giving you the highlighted bullet points of Act 67 and how it relates to conditional use permit hearings. There's a couple other things that I made note of on that page. On the left-hand column, second to last paragraph, there's some language that says that the new statutory language emphasizes, one, the importance of having clear purpose statements in the zoning ordinance. We do have a whole page worth of purpose statements in our ordinance that talk about protecting property values and wildlife habitats and water quality and wetlands and whatever else. I'm not sure how you measure a lot of that stuff, but we do have purpose statements in the ordinance. And then it also says that local governments should consider including a requirement that a proposed conditional use furthers and does not conflict with the local comprehensive plan. We don't have the language furthers in there, but we do have in our provisions, I think it might be the first one. Nope. Oh, third one. Whether the project is consistent with the Door County Comprehensive and Farmland Preservation Plan or any officially adopted town plan. So we already have that language in there that Brian Ohm is recommending. And then one other thing on that page that it talks about is that this law now makes it clear that if you're having a conditional use permit decision-making process, that you need to use a public hearing and a Class 2 notice, which we've been doing for decades. So the top of that third page, it's number 38 on his handout, gets at exactly what we were just talking about, which is the second larger paragraph basically says you need to be looking at your zoning ordinance and figuring out, whether all these things should be conditional use permits or whether you need more standards in your ordinance, and so that's what we're going to be tackling next. The frequently asked questions section of this is what, if you read something in there that sounds complete opposite of what we have told you tonight, that's where we kind of had some queasiness today when we were going through this. But those are the debates that are going on right now at the state. Not everybody agrees exactly as to what this means because of the sort of catch-22 that Nancy pointed out as far as substantial evidence and how you have to make the decision. I will say that the last two questions, so the second to last one that says, does Act 67's reference to only the zoning board mean that the plan commission and or governing body cannot grant conditional use permits, like we've talked about for now, and until somebody tells us otherwise, or until maybe the RPC and county board and board of adjustment decide that the board of adjustment should be doing conditional use permits. For now, we're going to do process-wise the same thing that we have been. And then the very last question gets at the appeal issue that we talked about, which we're going to keep doing what we have been doing until either we're told that we need to change it or we come to a realization that we need to for some reason. So you can take that with you and take a look at that later. The last handout that I have with regard to Act 67, again, it's not specific to Act 67, but Jeff and I happened to be listening to an educational seminar last week with Brian Ohm, and he mentioned this document, which intrigued me, so I asked for a copy of it. Because one of the things that people, oops, all right, this is going by, where's computer? All right, so things like, some of these standards are relatively vague, and if you remember the conditions that we're supposed to be attaching and the substantial evidence are supposed to be related to the purpose of the ordinance and yada yada. Is it similar to other uses in the area? That's sometimes a debate as to what exactly that means. Or is there visual harmony with existing buildings in the neighborhood? Does it lead to a major change in the natural character of the area? Those are all things that it's a lot harder to measure, and those are the things that both applicants and opposition and the Resource Planning Committee struggle with when they try, and the Board of Adjustment, when they try and make their decisions. So this is very short, and it's not crazy specific, but I found it a little bit helpful because what it does is sort of give you concrete things that you can talk about, or that you could even, in some cases, actually potentially measure to try and look at community character, whether it's the natural character of the area, or the physical built character of the area, or even the population character of the area. So I thought this might be helpful. We might be handing this out to all of our applicants as they're trying, and I guess any opposition as well. So we will probably, I'm guessing over the next couple of years, assuming things don't change dramatically again, be looking for things like that we can hand out to people. If people say, well, how the heck am I supposed to talk about whether there's visual harmony in the neighborhood? And we can say, well, here's an example of something that the American Planning Association has put out that talks about how to talk about, community character or whatever it is. So.
Well, my only, and I glanced at this, a couple of words kept kicking out of me, is urban.
Right.
We are primarily rural.
Yep.
And, I don't know, I'll read it and see.
It's still pretty good.
But it's, there's two different perspectives to
Well-
approach with, is the rural type or the urban type, so.
I think if you read it, you'll find that it's more helpful than you'll think
Okay.
that it is. And I also,
That's just-
and we certainly have, you know, downtown, we got Fish Creek, we got downtown Bailey Harbor, we got downtown Jackson Ports. I mean, we're certainly not urban anywhere other than maybe the city of Sturgeon Bay where we don't have jurisdiction. But I think this is a start at trying to give people something more concrete to talk about when people come up and say, it's not going to change the character of the neighborhood or the community, or it is going to change the character of the neighborhood or the community. This will give people at least some ideas about how to try and address that issue.
And yet, if we take a snapshot in time, anything beyond farming in my town
Would be out of
changes
character.
everything. It's
Yeah.
a moot point. But if we take
Well-
the earlier snapshot in time, anything beyond beyond forestry-oriented activities is a change in the character.
Right. And I guess the thing to keep in mind too, and so the Board of Adjustment, when they process variances, which is mostly what the bulk of the applications that they deal with, they have a statutory worksheet, basically, well, I mean, we developed it, but it mimics the statutes and the case law, that they have very specific criteria and questions that need to be answered by the applicant. So if you guys check off no on one of those things, the variance is supposed to be denied. It's a different type of decision-making, it's quasi-judicial decision-making, as opposed to the Resource Planning Committee conditional use permit decision-making, which is more, well, there's more gray area, I guess. So just because something is going to change the character of the neighborhood doesn't necessarily mean that you would need to deny it. You then try and figure out, are there conditions that can be attached that will lessen the impact of that change? So can we do screening? Can we limit the number of signs that can be up? Can we limit, you know, the hours, whatever it is? So that's something that we've been talking about off and on for years at the Resource Planning Committee. When the Resource Planning Committee walks through its worksheets, just because they check off something that is seemingly a negative about the project doesn't mean that the project would need to be denied. It means that's something you go back to and you say, how do we try and alleviate this potential negative impact? But obviously with Act 67, that discussion has got a whole lot more complicated. All right, so let's see what I haven't talked about yet. So as far as applications, we've already talked about how the applicants need to provide substantial evidence. Staff will be doing a lot of coaching or at least prompting to try and get people to provide information as thorough and complete as we can. But we will not be determining whether it's substantial or, you know, substantial enough to convince the Resource Planning Committee. Let's see, town review procedures. We already ended up walking through those as part of some of your other questions. Does anybody have any questions about the town review procedures?
Not so much about procedures, but a question I have with, you know, hearing you speak that it does appear that denying a conditional use is probably going to be a little more difficult. And I refer to county ordinance, zoning ordinance 9.02 regarding non-conforming uses as opposed to non-conforming structures. And Wisconsin common law seems to vigorously support that non-conforming uses are under a different standard. And this part of the ordinance in Door County says for all non-structural uses of land, except non-metallic mining operations, expansions shall be authorized only by a conditional use permit. Does that put, I don't know how many non-conforming uses there are in the county, but does that put the county at risk for expansion of non-conforming uses, or at least making the expansion of non-conforming uses easier?
I guess yes would probably be the short answer, and that's on our list of things to look at as well. In fact, so these amendments that I can kind of scroll through in a minute so you can see exactly what's being proposed on Thursday that are going to be hearing relate to the things that we felt that we had to do to Chapter 11 to be in compliance with this new law. So we have a number of amendments to, I think it's Section 1104, which is conditional use permits. Also on Thursday, we're bringing a whole bunch of text amendments to the Resource Planning Committee for potential sponsorship for public hearing to see their opinion on those. So, and one of them includes looking at actually putting a cap on the expansion of non-conforming uses. I actually, last week, went and read, well, I didn't read all of them, but I went and looked at the non-conforming use section of like 30 different counties in Wisconsin, and at the Center for Land Use Education, or the acronym is CLUE, out of UW Stevens Point, read their non-conforming use stuff, took a look at ours, and we're definitely going to be proposing a cap. I think even if Act 67 hadn't happened, that topic has already been percolating over the years. Because as I found out last week when I went and looked at these other 30 ordinances, we are probably one of the only counties that does not have a maximum at all. And many of them say nothing whatsoever is allowed other than just maintaining the building until it falls down. So, I think we've talked through quite a bit what I had on here. Does anybody have any other questions? Do you want me to kind of scroll through the text amendment pieces, or does everybody feel like you've seen those already? Have they gotten forwarded around between your planning commissions and boards? Yeah, Andy?
I had a question. They want to have a non-conforming structure, and they can rebuild within the footprint, and they can repair and maintain. What happens? Can they expand and go upward then, or do they have to remain in the same cubic footprint?
Okay, so under shoreline zoning, and the ZAs, please jump in if I get this wrong. Under shoreline zoning, a non-conforming structure is defined as one that's too close to the water. Those buildings we have to let completely rebuild in the same footprint. They're allowed to make the footprint bigger if they have to in order to comply with state or federal requirements. And we have to let them go up to 35 feet high. Is that all correct?
Right.
Okay. Non-conforming structures that are too close to the water, but that are back 35 feet from the water, at least, can also tear themselves down. Well, they can't tear themselves. Somebody can tear them down. And they can rebuild in the same footprint, get bigger if state or federal law requires it. They can go up to 35 feet high, and they can expand what's called laterally, so basically sideways, parallel to the shore, for another 200 square foot footprint, which can get taller as well.
Correct.
Okay. So that's under the shoreland ordinance, so that's in all 14 towns. Basically, your buildings that are too close to the water can be completely rebuilt and popped up to 35 feet. Some of them can also add a 200 square foot footprint that could also be as tall as 35 feet. In the comprehensive zoning ordinance, what we did a year and a half ago and what Act, whatever it was, 67 now requires, is that any non-conforming structure can be rebuilt in its three-dimensional existing box. So if you're not on the water and you're too close to a side lot line, you can rebuild what you have in that same footprint. Not just footprint, in that same three-dimensional space.
Same height, same roof.
Same height, same roof pitch, same, yeah. So it's a lot more permissive than it used to be. That myth was always out there anyway, so it's at least not. I mean, we'd always hear, oh yeah, if you leave one pole or one wall standing, you can rebuild the building. Well, now you know what, you don't even have to leave that pole. You can knock the whole thing down and rebuild it. Yeah. But I've been telling people, please don't just go do that. Have people call us before they decide that they're going to go whack it down, because there are other things that might come into play that might preclude them from doing that for some reason. So don't just go knock the building down. Talk to a zoning administrator and have them go out there and make sure first.
So in the comprehensive zoning, they can rebuild on the footprint, but they cannot go higher?
Right.
They cannot go. They have to go substantially whatever it was
before.
You could have a home that is too close to the water and too close to the side property line. So that's where it gets really goofy. So you could rebuild, if it's encroaching into the water setback, you can rebuild it and go up 35 feet, except for the part that's within the side yard setback. Then only the portion that was there can be rebuilt.
Yep.
Okay,
So you could have basically two sets of standards for one building.
Yeah.
Because there's a different set of standards for a shoreline setback, and then when it comes to road, side yard, rear yard, you can only rebuild what was there. So you can,
Yeah.
And we've already
Get
had those
complicated.
situations coming up, I think, in the last
I've had a
year and
couple
half.
of those, yeah.
Yeah.
And to muddy that further,
No,
you don't need any zoning permits for a lot of the work within that regulation point, but yet you still need your building permits.
Right, so for your shoreline, yeah, you need, under the shoreline ordinance, we're not even allowed to issue a permit.
Or
for
even a
those-
letter,
For those
technically.
non-conforming. No, that we can do
That
it,
you
but
can
we
do?
can't require it. So what we did, the budget bill from 2015 that basically essentially forced us to split our shoreline and our comprehensive zoning ordinance said that for those non-conforming structures under shoreline that are too close to the water, yep, you can rebuild it, you can make it 35 feet high. We can't issue permits for that work.
Shoreland.
Shoreland permits, sorry. We cannot issue shoreland permits. If you're in comprehensive zoning, we can issue you and will issue a comprehensive zoning permit to go along with that. But I know it's been creating confusion with the building inspectors already because let's say I have a non-conforming structure in the shoreland and, you know, they're gonna tear it down and rebuild it. They're also gonna add a deck that wasn't there before that is now allowed because it meets whatever our requirements are. So the zoning administrator just issues a permit for a deck. And then the building inspector goes out there and there's like a whole new house. So that's been happening.
It's
too.
a misconception
So, yeah.
that because they don't need a zoning permit, they believe they don't need a building
Well,
permit.
they don't get that from us because we
I-
tell
no,
them
I
to
under- no, I
stick that
understand that.
sticker on there every time. So, but yeah, but it's creating a lot of confusion. So yeah, if you're in comprehensive zoning, you're going to need a permit. But in many situations where you would have normally required a shoreline permit and a comprehensive permit, now you're only going to need the comprehensive permit for those non-conforming structures.
And just to add in one other item, the shoreland regulations and the prohibition on the permit for the shoreland permit has nothing to do with floodplain. So there are going to be floodplain regulations that have to be met. So definitely call us so we can walk you through all the necessary requirements and not just a part of them.
That's a very good point, because, yeah, floodplain is gonna, if somebody hears, oh, you can just tear your building down now and rebuild it. Well, if you rebuild something new in the floodplain and you don't comply with the floodplain elevations, you're gonna have a problem.
And then on top of that, you're gonna go visit your home insurance company and
Yeah.
find out that, guess what? Your policy just tripled.
Yeah.
Regardless, just always advise people to contact us at the county to see if a permit's required and contact your town building inspector. It's an easy answer, no, that you don't need anything from us if it's not even with any of our jurisdiction. It doesn't. I'd rather tell people no, they don't need something from us than us following it up after the fact.
Yeah. So, yeah, has everybody already seen these text amendments? Do you have questions about anything? Really what they do is kind of regurgitate a lot of what I just walked you through. So we've added, the fact that you need substantial evidence and that it's the applicant's burden of proof to provide that. So resource planning committee decision is supposed to be based on that. We did add those couple of new, excuse me, things at the end here, which we already had something in the ordinance that, oops, I can't read the whole thing, that said that the resource planning committee had the option of requiring financial assurance for something, but now we've added that on the list of things that they can consider as part of their decision making. Because again, remember, Act 67 says that if the applicant agrees to meet all the conditions, then you're supposed to be issuing the permit, and I guess that financial assurance could be if we don't believe that Dave's going to actually put in his stormwater runoff control system, we can require him to write a letter of credit showing that he's going to, or I don't know what, I'm not sure that the RPC will use it that often. And then we did add language, just again, general language about potentially problematic impacts of the use being alleviated by site-specific conditions that the resource planning committee might attach. And then finally, that again, the language that used to be in a different part of the ordinance about public health, safety, and general welfare. I will say that this was grants in my, let's say, let's call this probably a rough draft. I'm guessing that in the next couple of years, we will probably go through this list of things again to try and make them more clear as far as what types of things the Resource Planning Committee might be looking at, because if you go through this whole list of 17 things, a lot of them are extremely difficult to measure, and if much of what the Resource Planning Committee is supposed to be attaching to conditional use permits are things that are supposed to be measurable to the extent practical, we're going to need to take a look at this. So one thought that I had already today was maybe this section kind of gets overhauled to the extent that we keep most of these same concepts, but then we give examples of types of conditions or topics that might relate to it. I don't know. That's just one thing I thought of today, but this is just the bare minimum of what we thought we had to do to try and bring the ordinance into compliance with this new act. Anybody have any questions about these text amendments? There were also like a half a dozen what I usually call cleanup amendments at the end, which were literally cleanup in some cases. We need to change the department name in both ordinances to reflect our new name this past year. There's a couple of things that appear to be typos, but they've been in the ordinance so long that we're rectifying those. I don't think there's nothing that changes how we regulate anything anywhere as far as those cleanup amendments, which is why we didn't send any of this out for the extra review. The amendments that RPC is going to be taking a look at on Thursday to potentially sponsor will definitely go out for town review. And I'm thinking that we would probably do a meeting like this regarding those, maybe either at the end of March or the end of April. We can talk about that at the end when we pick our next meeting date, because those aren't going to go to hearing until probably May at least, at this rate. One topic that came up before that we didn't talk about, which we've talked about some at the staff level and the RPC that's related to this, is rezonings. So in a way, Act 67, even though it's about conditional use permits, really is going to put new pressure on rezoning hearings and rezoning applicants, especially if the applicant knows that they're then going to turn around and apply for a conditional use permit for something in this new district that they're requesting. We've talked at the staff level about how it's probably going to be advisable for those applicants to almost turn into full-blown applications at the same time, which we've never required before. We've always said it's helpful to the Resource Planning Committee in their rezoning hearing if they know what you want to do when you have a basic site plan. But we've never said, you need to have a detailed site plan and have everything really drawn to scale and have answered all the issues related to conditional use permit applications, because from now on, when the Resource Planning Committee is looking at whether or not to rezone a property, they really are looking at that, why it's being requested to be rezoned. They can't require the applicant to do what it is that the applicant says they're going to do, but if they're really serious about it, then maybe it is going to be in the applicant's best interest to provide really detailed information about their proposed project. Yeah, John?
Brian, if you offer 2 permits, request, is that going to be a double fee or 1 fee?
You're talking about like for shoreland and comprehensive? We've been doing 2 fees for the last year and a half. We told the Resource Planning Committee we were going to come back to that and see how it was going. So if you need a shoreland zoning permit from us, it's $100. And again, there's some things that the shoreland zoning ordinance regulates, but that we can't issue permits for, so those are free. And then your comprehensive zoning permit fee is the same as it has been. That fee schedule that's been in place like 9 years now, I think. We have talked at the staff level, every now and then somebody applies for something that's pretty dinky that requires a shoreline permit for $100 and a comprehensive zoning permit for $175 or whatever, and it seems kind of excessive for what the project is, but so far we haven't looked at changing that. Yeah. So anybody, I thought I saw a student's hand with regard to the rezoning topic. And that came up. Okay, let's see. So I think the last thing that I haven't covered is totally different, not related to Act 67 at all. The reason we have a new name, if you didn't already know, is because last year the planning department got merged with the sanitarian department and the real property listing department and the geographic information system land information officer from what was then called the information systems department. or information, and now I forgot their old name. Anyway, we're all one big department now. So we are called the Land Use Services Department. So the sanitarians are now actually part of our department. And we've been looking at internal processes and procedures and how things work this past year. And in addition to the merger that happened, another thing that happened right around the same time as the merger is one of the assistant sanitarians retired. So there used to be a sanitarian and then 2 assistant sanitarians. One of the assistant sanitarians retired and then that position was not refilled. So we are now down to 2 sanitarian staff members. We do have the zoning administrators are starting some cross-training. They've been going to some training about soil testing and working toward eventually getting some certifications along those lines. But so right now we only have 2 sanitarian field staff members. And one of the things that apparently has been happening for a number of years is that septic system installers, plumbers, whoever have been calling and saying, hey, I'm putting something in an hour. Can you drive up to Gills Rock? And staff has been running up there to do that. And now that there's only 2 of them, that doesn't always work because they may both be out in the field somewhere else, or somebody may be on vacation for that day or at a conference or whatever. It's also, we've determined that it's a lot of time and money that's spent just driving to do something for one person. So the policy that I'm going to have the resource planning committee look at, which all the staff think should be done and actually matches the statutes and our county code, is that for sanitarian-related inspections, so private on-site wastewater treatment systems, you're going to have to call the business day before. So the day before you want the inspection is when you're going to have to call, and then that way the front office staff and the sanitarians can literally map out who's going to go where in the morning or the afternoon that following day, so that it'll hopefully save a lot of time, because I think the sanitarian staff estimated they probably spend a quarter of their time in the car right now, at least, I think. And they might only be they might drive up to Gills Rock and then turn around and drive down the Union a couple hours later. And meanwhile, the other person may have been in Southern Door that morning and then going the other way. And so that's what that sanitarian item is related to. That letter, we're not going to send that letter out until the middle of March, because I'm actually going on vacation next week and I want to be around in case people call and have questions. So that policy will go into effect in April. Like I said, it's already written into the county code that the sanitarian staff have until the end of the next business day to conduct an inspection when one is requested. It's just, I guess, over the years we've gotten maybe probably a little bit too accommodating as far as those requests go. So, do we have any questions about anything else?
The February 19th memorandum on notifications and whatnot, does that apply to zoning changes also?
You mean like a rezoning hearing? A zoning map?
If someone wants to change zoning on a parcel.
Yeah.
Does
So,
it apply?
yes. So the old policy, and I was pretty proud of myself that I got it down to 1 page because the other one was like 3 pages, the old one. So yes, the process where an application comes into us and then we send it to the town, and you don't get to waive your review period anymore, and we're going to copy the neighbors and they can't bring in the letter on the front end, is going to apply to conditional use permits, appeals of RPC conditional use permit decisions, zoning text or map amendments, and variance petitions.
Now, if the town gets wind of this and says, oh, no, wait a minute, we're not going for that, and they send a letter down to you saying, we oppose this zoning change and will oppose it if it comes forward, then why would the RPC go through that process when it's going to be denied by the town anyway? Which has happened in the past.
Well, are you talking about it? So when the application comes into us and we deem it complete and we send it to you for your input, and then we get the input and we schedule the hearing.
But before this, we've already sent a letter.
Before we sent you the application?
Yeah, we've already made our feelings knowing and telling you what we're going to do, because we're going to deny this in the future. Why go through this whole process needlessly, because it's going to be denied by the town anyway?
Well, if the applicant comes and talks to you before they've turned in an application to us, I guess we don't care. It's not gonna save them time anymore because we're not gonna count that as the town review process. So even if they come and talk to you and you say, we hate it, and then they turn in an application to us, well, they have every right to petition for what they want to petition for. So we'll say, all right, fine, you paid your fee, you explain what you want to do. We're going to send the application to the town. You can then formally write to us and say, now we've reviewed the application that you deemed complete and we still hate it. But then the person still has their right to the public hearing at the Resource Planning Committee level. So
you're doing all this coaching now, wouldn't you tell them, well, the town's gonna deny this, you can go through with this if you want?
Well, the coaching part is going to be more for the conditional use permit part. I mean, we certainly will say, if you're petitioning to rezone, we think it would be a very good idea if you were very specific about what you want to do, because that's going to turn into the focus of the conversation. The last large handful of years, the focus of the conversation at the Resource Planning Committee for a rezoning application has not necessarily been what the person says they want to do, because we can't hold them to that. They just have been looking at, like, all right, does this district make sense in this neighborhood? Is it a better fit in the district that's there? And not so much what are they proposing to do. Now the focus is really going to shift to what are they proposing to do.
But it also focuses on what can be done if you go for, let's say, a commercial. Now,
Right.
Now you open up a whole can of everything.
Right, and that as well, like you guys and the Resource Planning Committee may love somebody's proposal. Oh, it's great that you want to rezone the commercial. We think this business is going to be fabulous. And then it can get rezoned and the person can turn around and sell it to somebody else and they can do whatever they want to. That's still obviously true. And that's kind of why actually the Resource Planning Committee has had the discussions more along the lines of the way that they have been doing it the last handful of years, because they've been looking more broadly at what could happen on this property than the person's specific proposal. But now I think with this new conditional use permit law, they're going to really hone in on what exactly that person is saying that they want to do. As far as why would somebody go forward, it's up to them. I mean, sometimes the town, they get a really negative reaction at the town level about a project, whether it's rezoning or a conditional use, and they kind of regroup and say, ooh, you know what, I think I'm going to withdraw. Or, okay, I'm gonna redo these plans and kind of start this process over. But they still have the right to go through with the public hearing for the rezoning if they want to. And I know, I mean, the towns have what we always call the veto authority, even though that word isn't used in the statutes. But if you don't file your paperwork properly or in a timely manner, or your certified resolution disapproving it isn't deemed to be in the correct format, then you lose your veto authority, basically.
Well, if the town's watching it, though, they're not going to.
Pardon me?
If the town's watching it closely, they're not going to lose it.
Well, if they don't file everything correctly, or something happens and you didn't post your meeting, or I don't know what, if there's something where you don't follow the legal process to use that authority, because most of the time, and I know Jeff has wanted to pipe in on something, so I'll let him do that in a minute. Most of the time when you guys are writing your letters saying, we don't want this rezoning, we don't think this should happen, almost none of you are ever, with that first letter, sending in a formal, official, certified resolution of disapproval of that zoning request. So maybe that's something to think about. Maybe you want to start doing that. If you're really against somebody's rezoning, then maybe just go ahead and lay that out there right away. And then the applicant probably would withdraw, I guess, at that point.
Well, I think the answer to your question is, if you, as a town, submit a letter to us just saying, or talk to us saying that we're vehemently opposed to this and we are going to use our veto power if it does go to public hearing, we can certainly relay that to that applicant, but it's still their right to petition for the rezoning. And once they submit that application to us, we have the obligation to start the process and go through the public hearing. So we would try to stop them on the front end, because we don't want to waste everyone's money and time.
We did have a certified resolution early, like you're talking about, years ago, so it's been done.
Okay. Yeah, I can only think of.
Well, that could be done at the town meeting level too before it gets to public
I know,
hearing.
yeah, but I'm saying that none of them. I can think of one in the last 11 years where we got a certified resolution as opposed to just the town saying, we don't like this and this is why, which, you know, the resource planning committee generally does pay pretty close attention to those, but not always. And so then, yeah, I think the one time I can think of where somebody actually filed a certified resolution protesting it was when that exact thing happened. An applicant petitioned for something at a meeting and said, we don't like this, we don't want this to go through. The Resource Planning Committee voted to recommend the county board to do it anyway, and then that town regrouped and held a meeting to actually file the formal paperwork to get it blocked. So, yeah, Nancy?
With regard to rezoning, how much weight does the RPC put on, for instance, compliance or compatibility with the town's comprehensive planning act?
Well, I would say they put a fair amount of weight on the town's letter. Not all of the towns always talk about their plan explicitly in their input forms. But I mean, that's kind of one of many things they're considering is why is this being like what's the project that's being proposed for here? Is it going to be significantly different in intensity or density than neighboring properties? What's the input that they're getting from the neighboring properties?
I guess my question kind of goes to, is one of the considerations that the RPC would be looking at is this rezoning request consistent with the town's comprehensive plan?
Yeah, I mean, I usually give them, there's a staff report that we have a framework that we put together a couple of years ago, although that's in the pile of things that we now need to look at for all staff reports to see, because of Act 67, if we need to change the wording of some of that. So Becky does the staff reports for things that are going to the Resource Planning Committee, and so she'll take a look at what, like the comprehensive plan future land use map. So you're in a residential district and you're asked, or not district, but residential future land use category, and you're asking to go to commercial. Okay, potentially a strike against you depending on what it is that you're looking at doing and that kind of thing. And are there any goals in the plan that support or don't support the actual project the person says that they're going to be doing? So those staff reports, now that I'm talking and thinking about it, are probably going to shift to be kind of almost more like the staff reports we give you for conditional use permits, where we actually do analyze more so the use that's being proposed as part of that rezoning, and not just looking at, is it spot zoning, or, yeah. So we have a lot to do.
Mariah, you used a hypothetical before about trade something in an agricultural area. As an example of what you would look at, what you will eventually look at to make either more specific or maybe remove the conditional use from that category altogether. And let's say that, using that as the example, let's say that on March 1st, a conditional use application for that kind of conditional use that hasn't been looked at yet by the Land Services Department is applied for. The county then decides to pull the conditional use from that land, that category on April 1st. The original application has not been settled yet. Is that going to, is the change then going to be retroactive to that application that hasn't been decided yet?
No, we would, so for years and years, when somebody applies for something, assuming that they turn in a complete application, so it can't be they just give us a piece of paper that says I'm going to do a trade contractor on this property, we don't have plans or a fee or whatever it is that we need to determine compliance with the ordinance. So whatever the rules are when they turn in a complete application that day, those are the rules that we apply on that date. And then remember, we've got kind of that related issue with that other piece of the other bill, where if they've applied to you guys for something 3 months ahead of time, then we have to use those rules, even if ours have changed as of before they turn in the application too. But yeah, we use the rules that are in effect that date. Do we have any other questions about anything? We're gonna get you out of here early. Okay, so next meeting date and topic. I usually try and do these on like the 5th, whatever, of the month, because I figured you'd want to have standing committee meetings those dates. So we have March 29th, which I already forgot what day of the week that is. I think it's the
Thursday.
5th. Okay, thank you. March 29th is a Thursday, that's the 5th Thursday, and then April 30th, what's that one, Dave? Is that a
Monday.
Monday? Those would be the next two possibilities. I don't know yet what's going to happen at Resource Planning Committee on Thursday. I'm assuming they're going to sponsor some or all of the amendments that we've got, in which case March 29th would make sense to talk about them, but I won't know that until Thursday. Otherwise, we could go April 30th. Or if there's something completely different that you want to have a meeting about, we could do that on March 29th and do the amendments on the 30th. Or is there anything planning commissions are looking for?
Where's the state sit right now on that filling of wetlands?
Waiting for the governor's signature.
It's still at that point, it's at the station.
We're fairly confident he's going to sign it.
Wow.
That might be it. I wonder if Jeff's turning into our resident wetland expert. Maybe we can. Well, do you want to kind of hold both of those dates, or I can email everybody tomorrow and say hold those dates, and we'll decide in the next handful of days whether to do. Okay. The wetland one that there's a number of unknown. Does everybody know what we're talking about with the new wetland bill? Okay. You want to give a brief primer?
So with that new wetland bill, they define different types of wetlands. There's federal wetlands and there's non-federal wetlands. The new wetland bill allows for certain filling of federal wetland or filling of non-federal wetlands. Within urban areas, you're allowed to fill up to 1.5 acres, or something, either 1 acre, 1.5 acres, and outside of urban areas, you can fill up to 3 acres with the new wetland bill without any state approvals.
No oversight, no nothing.
No oversight or anything like that. So most of the changes are going to occur at the DNR level, but one of the provisions within that bill is that the local municipality, so the county in this case, we cannot be any more strict than what the state is. So we can't regulate it any more strict than what that bill is saying. So in a nutshell, it just allows for filling of wetlands without any approvals or oversight from the DNR.
The things that make it more complicated, although potentially better, if you're of the belief that wetlands should be filled, are that there's a whole list of certain types of wetlands or certain state designations. I forget what all the acronyms are.
Areas of special natural resource interest, those are designated by the DNR. And then there's certain types of wetlands that they're looking at preserving also, which is an extensive list. Even with, what's a federal wetland versus a non-federal wetland, that's determined by the Army Corps of Engineers. And then different designations of these special rare wetland types that cannot be filled, the DNR doesn't even have that type of information for like a GIS layer on the web map. Last week I was at a training and was with some DNR folks, and even they didn't even want to comment on it yet because it still hasn't been signed, because they don't really know how this is going to be enacted, and they have until July 1st to figure out how to enforce it and how it's going to be enacted.
So what I was hoping we could do, but like Jeff just said, it's not going to be that easy. I was hoping that somebody somewhere had a map of which wetlands are federal and non-federal. And I was also hoping that somebody had a map of which wetlands fell into, I think there's like a dozen categories that are potentially protected that this law wouldn't allow to be filled. Because then I thought, well, we could overlay all those and then we can cross-reference that with Door County's, our wetland layer, and see like what's left and in danger. But there are no such layers. A
lot of hopes in there.
Stay tuned. Well, it seems logical that somebody would have that information, but they
It's
don't.
legislation.
With an illogical
So we're gonna send
legislation.
Jeff out with a backpack for the next 5 years. He's gonna tramp around the county, and identify all of them. But, yeah, anyway, okay, well, like I said earlier, I will email everybody the handouts that I used today. I didn't ask for emails on that sign-in sheet, so I'll just send it to the clerks, the plan commission chairs, and board chairs again. And then just hold those 2 dates and stay tuned as far as if we'll meet one or both, or what we'll talk about.
Brian,
Yes.
can you put these meetings on the county meeting calendar? They're present, at least this one was not in that calendar. That's easy to look up something if it's there. Is there any reason why we couldn't do that?
Why I historically haven't done that, they're obviously public meetings. I mean, we posted it as if it was a Board of Adjustment and RPC meeting, and anybody can come. But historically, the only people I've officially invited are town officials, because it's really geared for information for them. And plus, we're almost at full capacity, although we could rearrange them maybe a little differently, but I can find out. This isn't any official like governing body, and usually the only meetings that are on that calendar, I think, are committee meetings. Do you know, Linda?
Public informational. That's what this really is.
Okay, I can see if I can post them. So that would be on Jill's calendar. Okay. Okay. All right. Thank you.
Thank you.